Thank you.
Can we start?
Yes, please start. Yes.
Okay, hi. Good morning, honorable members of the Blood Tribe panel. Okay. Okay, my name is Lori Scout, State B. And good morning, honorable members of the Blood Tribe panel. Thank you for the opportunity to present my appeal. For the record, Bonnie Healy was on my list of appeal witnesses, and I object to that because it was last minute notice for her to not be here because I was going to question her. So I object to that, and she's needed and required here to provide evidence, and according to that, that's a breach in the policy. Section 25.8, the notice of appeal and the response, if any, and the evidence applied in the connection with each, shall constitute the record for the purpose of the appeal. Any evidence. So there's a breach in that. She was already listed on my record of appeal, or as one of the candidates to list, and so therefore, for the record, I object to that, and that's a breach in the procedure and the bylaw. Okay, so to further move on, I'm just going to talk about my submissions. Just a quick note before I start my submissions. I can find it. I object to any denial of my evidence or appeal grounds, as there was no hearing to reach that decision, and I was not afforded any opportunity to be heard. I attempted several times to obtain clarification regarding the appeal process and who was on the panel, first from Lance, then on December 2nd to legal counsel Glenda Spotted Eagle, and then it's contained in my formal appeal file December 3rd, 2024. Not one person replied. The panel had an obligation to reply, and I could have added all of my evidence before the appeal date, including my extra witnesses, but they had just popped up too, the new ones. The date appeal filing in a way in advance, not even knowing what the date of the appeal was to be filed. So again, the panel had an obligation to reply, and I could have had added on all of my evidence before the appeal date elapsed, filing way in advance, not even knowing the date the appeal must be filed. That was not mentioned in the appeal book. The December 16 meeting was not a hearing. Therefore, no decision can be made by the panel. This violates the bylaws and due process, and I was not heard on any decision made as a result. The panel has unilaterally changed the rules and bylaws itself at every gate. Overall, this all amount to the total denial of procedural fairness for the record and breach of natural justice and the rule of law for the record. Let the record state clearly that I have been denied witnesses to Kristen Firstrider, Randa Weaselhead. Who else? We have been denied also. Darren Curly Rider.
Tristan.
And who?
One bed.
And Bonnie Healy, etc. So we have been denied. All evidence and grounds and witness testimony for the record. This will now end up in our court, given that all procedural unfairness breaches to date, apart from the election irregularities that are proved with my evidence. So I'm going to read my submissions right now. Today we confront not just procedural irregularities, but fundamental issues that threaten the integrity of our electoral process. Number 3, we and I state for the record that the entire pre- and post-appeal process has been procedurally unfair. The appeal panel has breached the very bylaws it is to enforce and has made the appeal process very unfair. Bias, lacking adequate notices, or procedural or unilateral last-minute changes and decisions were made leading to today's appeal, which compromise the integrity and the process at every stage. Number 4, detailed particulars appear to our letters and joint appeal record. See pages 12, 13, 21 to 27, 28 to 61, 119 to 120, 327, and page 340. And within the questions sought and ordered for us to produce within a few days' notice in advance of today's appeal. Number 5, No one has provided us courtesy replies to the questions we were forced to produce on Saturday or Friday, and further compromises our ability today without the answers to questions required.
I'm gonna have to stop you.
With respect, I would like to, I would like to
I'm the
finish my
chair.
submissions.
Chair, please.
Yes.
Please, thank you very much. I need to remind the appellants that the submissions, oral submissions, is only in relation to your original notice of appeal that was submitted to the appeal board on December 30th.
Well, again,
You provide a 118-page document of additional submissions, additional witnesses, additional evidence. And we denied those by email, but not I, but pardon me, the board denied those last night in the email that you would have probably received.
yes.
So all the statements you've made thus far are making reference to that document. So you need to stick to your oral submissions concerning your notice of appeal that was dated or received by the board of December 3rd.
December 3rd. Well, with respect, this is part of our oral submissions, and it does not say anywhere in the policies that we are denied to present these submissions. This is part of our oral submissions and our evidence. It does not say anywhere in the policy, so that's a breach in itself. So I would like to please continue.
I would reflectfully disagree. All the statements you made thus far are making reference to your submissions of yesterday.
But it's also in response to what is procedurally and unprocedurally unfair. This is part of the entire process. We're allowed to do this. There's nothing in the bylaws that says we can't.
Yes, there's nothing in the. This
So-
is not with
so
respect
for the
to
record-
excuse me.
Yep.
This is not with respect to what is stated in the bylaws. We're simply talking about your submission.
Mm-hmm.
So your submission is based on your notice of appeal that was submitted to the appeal board December 3rd. We've all got a copy, that is, the board members all have a copy of your original notice document. So you making references of procedural fairness up to yesterday.
Yeah.
So that is something that we're not talking about procedural fairness because you did not raise those in your original submissions.
Okay, so for the record, you're denying us our arguments and our statements to provide and prove that there has been unfair procedures in this entire process. Is that correct?
That's not what I'm saying.
Well, that's what these statements are for. It's to provide evidence, and these are my statements.
But
To provide evidence that there has been procedural unfairness.
But you are making what you're not to make it clear. The statements you made thus far are derived and coming from your submission of yesterday.
Okay.
So they're not deriving from your original notice of appeal. So if you could stay on course, please. Thank you.
Okay, well, moving on. I want to emphasize that all the evidence, I'm just introducing it, all the evidence supporting facts and crucial issues that have been duly served to the panel, One Feather, Mrs. Spotted Eagle, and part of our joint appeal, we repeat herein, so everything that we have, so we're not going to repeat all the questions now, we'll wait till the witnesses come in. You guys already have the questions starting on Appendix C. So we repeat herein, but will not repeat all of the details today, given the further restrictions. And we will not tolerate any detail due to time constraints. So we're not going to read through all our questions before they come in. We're going to call the witnesses as they come in and read those questions to them, because we're on a time constraint. So I adopt and incorporate the entirety of our appeal record into the record as if fully repeated. So for the record, you are denying me, you are denying my first witness, Kristen Firstrider, is that correct?
Kristen Firstrider is not on your original list of witnesses on your notice of appeal of December 3rd that was submitted to the appeal board.
Okay, thank you. All right, so again, I did ask you several times, right? Several times before, and in my appeal record, when I filed December 2nd, and when I filed on the 3rd, I asked several times. You guys never responded back to my questions. When can I submit my evidence? when can I submit future whatever details that are required. None of you emailed to Lance, you guys got the joint email, you guys never responded back. So again, I'm going to remind you for the record, section 25.8 of the bylaw, the notice of appellant and the response, if any, and the evidence supplied in connection with each shall constitute the record for the purposes of the appeal. It does not say that there's a restriction if new witnesses pop up. There's no clarity. There is nothing in the bylaw that states that. If there is, can you please point to me that says in the bylaw that it does? Thank you.
Proceed.
Okay, I'm asking you a question.
Proceed.
Okay. All right. So again, I wanted to call for the record. I wanted to call Randa Weaselhead. For the record, you're denying me my call for witness Randa Weaselhead. Is that correct?
If she's not on the original list of witnesses,
Yes.
she's not allowed.
So yes, just confirm, yes, you're denying me. Yes, thank you. And that again goes back to subsection 25.8 of the bylaw. The notice of the appellant and the response, if any, and the evidence supplied in connection with each shall constitute the record for the purpose of the appeal. It does not say if there's any evidence that comes into future, at the time, last minute. I'm sorry, but yes, that's a breach right there and a violation. Okay. The next witness I wanted to call, I guess we'll call in. Peter Chiefcap. Actually, can we take a break because, can I have like a 5-minute break? Because I need to like make sure the witnesses are out there, because this list, and there were others that were coming that we were denied. They don't know for the record that they were denied and they're sitting outside the door. So could I take a 2-3 minute break?
Granted.
Okay, thank you. Okay, I think I'm ready to continue. I guess I just want to clarify something, that we filed individual complaints, but we filed a joint record to provide efficiency to the board. You need to turn that off. We need to provide just to provide for efficiency to the board, and when we do file for a court process. All right. So, anyways, I guess the next one, I guess, is the next witness. One Feather has, as in our letter that you've written to us, that One Feather has decided not to participate in the appeal. For the record, One Feather has refused. Is that correct?
They provided a response that they were not going to attend.
Okay. All right. And did they provide the answers back to the questions that were due for today? Did they provide the answers back?
No. So what had happened is, in their reply, is that they were not going to attend. However, that we could ask specific questions in relation to their election or electronic platform.
You can ask, or we can.
So the board, asked questions and emailed those questions to the contact person of One Feather on Saturday.
Yeah.
And so in the board's letter that was submitted to you dated January 9th, we urge you to ask questions to them too.
All right. Okay. So again, and again, that's also, I'd like to make that for the record, that One Feather has refused to provide witness. They are a crucial witness, and it's to help bring clarity and to help with procedural fairness. Their evidence is important to be, and their answers to their questions are important to be answered, that help provide the results to this hearing. I would just like to say that for the record, that they have refused to appear. So the absence of One Feather in attendance at the hearing is a critical oversight that limits our ability to present an adequate defense. For the record, we have new evidence and witnesses whose input is essential, and their inclusion should not be restricted by the appeal board. For the record. All right, and that goes back to section 25.8, the notice of the appeal and the response, if any, and the evidence applied in the connection with each shall constitute the record in the purpose of the appeal. So again, there's another breach in the bylaw. That's what I'm referring to. Thank you. So limitation of evidence disallowing witnesses and evidence contravenes our right to a fair hearing for the record. All right, and failure to provide adequate notice, the 1 day's notice given for us to present our case is unjust and obstructs our ability to prepare adequately. And inadequate review of appeal documents, the lack of transparency in the review of our appeals raises significant concerns about the integrity of the process. Okay, so for the next witness, and for the record, one feather did not make it, and that is affecting the integrity of the entire process. All right, the next one, witnesses for examination. I would like to call my first witness, Peter Chiefcalf. Hi, Peter.
Hello.
I think you probably give him a share. I don't know
On
what my
this side?
questions are.
Yeah,
Oh, it's over there?
sorry, on this side, please, sir? Thank you.
It's on the other side? Yeah.
I think there's a mic
Just
right
yeah, you can
on the
just
table.
sit it over there on the mic.
Good afternoon, Peter.
Hello.
For the record, can you please state your name?
Peter Strangling Wolf. I go by Chief Cap.
Okay, thank you, Peter. Thank you for coming. I guess first question, did you participate in the Blood Tribe elections?
Yes, I did.
What did you participate in? Did you vote?
I voted.
Did you vote online, in person, or
I voted
mail-in?
in person.
Okay, and after you voted where did you vote in person?
I voted here in Standoff.
In Standoff, okay. And after the election, or after you voted, did you receive an electronic email stating that your vote was successful?
No, I didn't.
Okay, thank you for the record. He voted. He did not receive an email saying that his vote was successful. So that means that this was not a spoiled ballot. Thank you. Okay, next question. Are you aware of any unfair practices that have happened within the election?
Well, on Facebook, there was a little article about one of the council that got in. He was a Democrat, was buying votes, was paying somebody for votes. That's the only thing I heard about. I think it was to the late Sheldon Wells, something like that. Anyways, that's one thing I heard about. Somebody that from council, that was the nominees were paying money for votes. That's one of the things I heard about.
And might you know the name of that counselor or candidate that was running in the
yeah.
election?
Because that Binakli,
Okay, for the record, he has stated Binaklayim has confirmed that he has participated in vote buying during the campaign period. Okay, all right. And is there any other practices of
there was something that bothered me when we were in line for the elections. One of our members, one of our group members was running for council, and she didn't have her criminal check. So they told her to go to the police station and get it, but she didn't get the actual form. But she had the document saying that she paid. You know, when she came back, they wouldn't accept it. And I thought to myself, why wouldn't they? Why wouldn't they? you need the actual document that says, you know, that takes 2 weeks to get here, or at least a week. You know, where I thought they could have accepted that her run. You know, she had already paid, and it stated she did the criminal check. That's something that's wrong to me, that should have been accepted by the electoral office. I could be wrong, but, you know, it bothered me for quite a while. Still bothers me today why, you know, things like that, we should give everybody a chance. They did what they were required to do, and yet this person got denied of running for council.
Okay, thank you. I've got a couple more questions. Can you hear me? Can you hear me? Okay. All right. So, do you feel that that the notice to call the election, it was let's see, November 22nd. It was stated in one of the media things that November 22nd that they called for nomination. Do you feel that they gave it an adequate advance to the members to get adequate notice and to? Oh yeah, okay, I'll stop there. Did they give? Do you feel that they gave adequate notice to call the election?
No, absolutely not. Because I had posted on Facebook a few times. I posted that why are they not calling elections early? You know, from way back. There was no notice of an upcoming election out here. Oh, we're not going to have elections. We've already picked whoever's going to be right. That's what you hear, gossip, which some of it might be true. I don't know. But the way it turned out, it seems like it's true. You know, I posted that many times. Why aren't they calling elections? Give us some time. Give people time to campaign. And then this protest started. And as soon as the media got involved, all of a sudden you hear, hey, we're going to have an election. You know, that short a time, I think the media had not been involved, they wouldn't have called an election. Or maybe a very short, much shorter election. But, you know, those things bother me. Why are they doing this to our people? You know, that's dictatorship. It's exactly what it is. They don't care about the people. They have in their mindset, oh, the people's not going to care. They never come to meetings. They're not going to care. Let's just do this. But we care. That's why exactly why we're here now. Because we do care. Nobody's ever challenged you people. Now it's time. You got to straighten things out. You know, none of this is going too far. What the election board's doing, what tribal government is doing, it's time we stop and care about the people, what they think. Give it to the people. Let's see what they think about it. If you're going to change policies, give it back to the people. Let them decide. When you decide on your own, you're just doing it for your own benefits. It's not for the people. It's for you people. You know, these things bother us. You know, there's a lot of us elders out there. It never bothered me in the past. It never bothered me. I was younger, crazy. I couldn't care less. But now that I'm older, I realize what's going on. And it's not right.
Okay, thank you, Peter. I got a couple more questions. Okay, so do you think that adequate notice and fair and adequate notice was given to the candidates to get their criminal record checks before the nomination?
Well, no. Well,
no. Yes or no? Do you think that,
like I said,
it was like how many days before?
The campaign part is not long enough.
Okay.
So why would it be? You know, it just shortens that too.
Okay. All right. Thank you. And as far as you're concerned, were you ever notified before or at nomination day of the appeal board members?
No.
Were you given any names of who the appeal board was?
Electoral officer.
And that was it?
That was it.
Okay.
And I wasn't even aware who's on the board.
Okay. All right.
I see him now.
Okay.
I didn't know what he did.
Okay, thank you. All right, and again, I'd like to say that for the record, that no notice or announcement was given to provide the names of the appeal board And in regards to conduct and public interest violations, the actions of the appeal board of the CEO plans reflect a disregard for fairness and transparency. Okay, thank you. I'd like to call my next witness.
Ms. Scout,
Yes.
could you help the board understand which grounds of appeal, that is paragraph under your notice of appeal, that the witness provide supporting evidence?
The witness provides supporting evidence. Excuse me?
Yeah, so in your notice of appeal,
Yeah.
you state a number of allegations listed
Yeah.
out.
Okay, I'll go through those.
So it helps with the record, it helps with the decision writing of the appeal board to make reference to what paragraph that your witness is providing supporting evidence to. Thank you.
Okay, thank you. I'll go through those. Okay, here I am. Okay. This is the ones that, you're referring to my appeal record. And,
Yes,
and the
yes.
bylaw, okay. All right. So, number 32, that would point to number 32. And governance violations in chief of council.
32 was disallowed.
32 is disallowed. Okay. All right. Again, for the record, all of my points that you mentioned that are disallowed. Again, that is procedurally unfair because it disallows me to basically provide my evidence. And again, I do object to that because that's in 25 where it says the notice of appeal and the response, if any, and the evidence applied in the contentions with each shall constitute the record for the purpose of the appeal. This is, you guys are denying me my right to provide evidence to support this, and this is procedurally unfair as well. You're basically limiting us to provide proper evidence for our grounds. For the record. All right? I'm just trying to find my papers because I flipped them all over.
Am I good to go?
Yes, you may go. Okay, thank you.
Oh, yes, Ms. Scout, we have one of the board members who wanted to ask a question.
Yeah.
Just to make it clear, okay. We want to know what section of the bylaw
Yeah.
was violated.
Oh, okay.
Okay. What section of the bylaw was violated?
Okay.
That's what we want to know.
Okay.
That
Right,
was
and
section
it
25.
goes back to 25.8. It's that, like, providing evidence and also, what? They're all connected. They're all connected to the questions because anything that we ask for, you're denying a majority of my points to be even questioned, to refer back to the bylaw where they're breached, and that's how we're supposed to plead our case. For the record. This procedure is completely, unfair. All right, so I'll go back and I'll check. All right, so I'm going to refer to point 16. I'm going to bring that up. The entire election process exhibited a lack of procedural fairness, essential for legitimate electoral proceedings. Candidates were not informed of their rights or the procedures relevant in the election, undermining the foundational principles of democracy. Number 17, there are witnesses available who have evidence that serious discrepancies occurred with the online voting process, such as the system permitted multiple voting by the same voter or denied other eligible voters from voting. All right. Okay. All right, so that's to read off some of those arguments that were in here. That's from point 16 and 17. Okay, and number 21, again, I'm going to recite it. The above, in addition the lack of transparency, security, and protections required of the ballot boxes in the other polling stations such as Calgary and Lethbridge. I just had to put that in there because this is part of the entire election process. Okay, all right, so I'm trying to go through these questions. All right, so for the next, my next witness, I would like to, okay, I'm just going to open up my page with the questions.
Okay, so, and again, Ms. Scout, if you wouldn't mind, assisting the appeal board to which area of the grounds of appeal that your witness is going to provide supporting evidence. Thank you.
Yeah, okay. All right. And I'm going to go into the next witness because I'm going to put back and forth here because this is procedurally unfair, this whole process. The way you guys are dictating how to basically give our evidence and our grounds for the record. Okay. Okay, I'd like to call in our next witness. I'm just gonna see if I can get my page open. Okay, I would like to go to my next witness. No, she can't. She's not, no. It's gonna be
I don't know.
Lance Tailfeathers.
Yeah.
You're after me.
Okay, sure.
Lance Tailfeathers.
Is Lance still in the lobby?
You never stopped by with these chairs.
Yeah, they're all sitting over
Yeah,
here.
can you bring him? Okay. Are we gonna bring him in? I don't know. He's in the lobby here, so.
I'm just gonna go through those questions fast so we can get this one.
Teresa's not here at the
Yeah,
moment.
well, when it's your turn, you can call her in.
Oh, yeah.
Just tell her.
Lori,
Yeah,
just to let you know that it's now been 35 minutes.
okay, yeah, and what time are we done?
You're done at, so you started at 11, so at 12.
12:50?
12:15, sorry.
12:15. We're going till 12:15, and what time is it?
It is 11:20.
Okay. All right, okay. Okay.
For the record, I just want to make it clear that, Mr. Tailfeathers, it is the appellants who are asking you as witness to their questions. So it is not us, pardon me, I keep saying us, the board, the BO board, that is calling you as witness to ask you questions. So be clear that you're here as being called as witness for the appellants.
My understanding is when I was notified was to be the witness for the appeals board, but as far as the appeals, I was not notified.
Yeah. So I guess that would be your choice.
I don't wish to, I was formally prepared for what they were gonna ask me, but yeah, I just, I don't feel it's productive, because I was called as a witness. But if they did notify me, that would have been warranted.
So,
At this point, yeah.
okay, so for the record, you are not going to appear as witness for the appellants?
Okay, for the record, I would just like to say that Lance has refused to provide witness, even though he is on our witness for examination list, and even though we supplied questions that were demanded from the appeal board, that they were supposed to answer. They should have, they basically gave us 2 days notice, and that's why I'm saying here, the fact that you're not providing any evidence to us as a witness is showing that you are basically breaching the bylaw, section 25.8. Who has my book? Section 25.8, where of the bylaw, this is a discrepancy, have it for the record, that on 25.8, the notice of the appellant, the response, if any, and the evidence supplied in connection with each shall constitute the record for the purpose of the appeal. Your information and your witness statements are very crucial in determining the outcome. So this is a very serious breach in the bylaw, and your lack of participation. And where's my paper? I would just like to also say, we object to you making your decision of removing yourself to the appeal, because the appeal board, you were all given notice of the appeal on December 3rd, and then you're on there.
It was
So,
fair.
because you're denying it, you are
I couldn't go across. That's not enough. I got one.
Just to be
Can we
clear,
please take a break, like a 2 minute, we'd like to take a little break for 2 minutes.
Sorry?
We would like to take a 3-minute break.
Granted.
Okay, thank you. Yeah.
Is it on? Okay, we'll continue.
Okay, all right, so just to continue to the board, in regards to Lance's refusal to provide witness testimony for today's hearing, and the board not compelling Lance to provide evidence, it is a breach in the bylaw, section 25. So Lance's conflicts of interest and serious issues of grounds, Lance's conflict of interest have serious grounds of the appeal during the selection process. And they are serious violations that we raise in our appeals. Refusing to answer questions must be taken in the affirmative as being true. Whatever's in our appeal record, whatever statements we made are to be affirmed as true for the record. Thank you. All right. So my next witness, and yeah, that's the breach violation again. That's a breach on the board for not compelling him to provide as a witness. And that goes against, okay? All right, so the next witness I'd like to call in will be, let's see who we got here. Beamer, Binagoyam Tailfeathers.
DUANE, you want to go?
Is he here?
Yeah, he's out in the lobby.
Just so that you are aware, Mr. Tailfeathers, the board had asked you as witness, as according to the elections regulations and bylaw, to answer some questions with respect to the notice of appeal of the appellants.
Okay.
Now, the appellants are now calling witnesses in respect to their notice of appeal. So they're calling you as witness, not us at this time.
Okay, I was notified that the appeal board was the one that was calling me as a witness, so I needed to be notified by the appellants prior to this today. Yeah. I needed a notification if I was gonna be a witness for you, so yeah. So I refuse, but I will read my statement to the board when you request me to. Yeah.
Thank you.
again, for the record, I object to Bina Goyam not providing witness, Binakoyam, thank you, Binakoyam not providing any witness statements to our hearing today, as we did provide the questions for him. You guys, the board requested less than 48 hours before, and we provided those to you yesterday, and he has not provided. So again, for the record, I would just like to say that adequate notice to ourselves as well as him, that there was no fair and adequate notice for the candidate as well as for the appellants here, and that Bina Goyam has refused to witness, and the board has also breached the bylaw by not forcing Bina Goyam to by not compelling him as a witness to provide statement, and it is a breach in the bylaw, section 25. In addition, I would just like to say that the Bina Goyam's conflict of interests has serious grounds of appeals, concerns during the election, and questions. His conflict of interests and his participation in corrupt practices during the election was required, and it was an important argument in the grounds for our appeal. So refusing to answer the questions must be then taken into the affirmative as being true, and the panel has equally violated clause 25 in refusing his testimony and compelling him permitting another witness not to be compelled. This is all procedural unfairness and breach of the bylaw and appeal process for the record. Okay, thank you for the record. I guess I'd like to call, I don't have all my questions that were directed to One Feather. They are not here, and their questions are part of the process, and that was one of the serious grounds. I'd just like to say that they have not shown up to provide it. That you as the panel or the appeal board, that was your duty to compel the witnesses when we had requested anything to do with the notice. We got the same, we were only given 48 hours notice to get these questions ready, so I don't know why we got these questions ready. So again, for the record, there was no sufficient notice. So there's just a complete breach in the whole process of this appeal. And excuse me, let me finish. I'm almost done, and then I'll let you go. So right now, I can't get any evidence, even with the witnesses that I was requested and provided, the ones that you did call in. That was on you guys to call them. I couldn't call them. You said you're going by the appeal record. So that was on the board's responsibility to give them notice that they were going to be providing witness to our questioning. So that's back on the board. And I'd like to just kind of move on. And Lenny, would you like to call any witnesses?
If I may just reply on a statement that you made. You made a statement that it is the board's, to the effect that it's the appeal board's responsibility to call your list of witnesses. Mm-hmm. It is not the appeals board's responsibility to call your witnesses. It is the appellants. These are your witnesses. It is your responsibility to have them prepared and come here.
Okay, for the record, you just refused me when I asked the ones to show up. Section 25 to provide evidence. They showed up for the record. We did provide them. We asked, we knew who was on here. These were our witnesses, and then we had additional ones, but you guys denied them. So that's a breach in the bylaw, section 25.
See, this is going back to your earlier statements in this proceedings, making reference to your 118-page document of yesterday. So the board, the board had notified you last night that we're only allowing your original notices of appeal, record, and your list of witnesses.
Yes.
Anything beyond that you mentioned in your submission yesterday, additional witnesses, additional evidence, sorry, that's me.
That's okay. Take your time. No worries.
I am so sorry.
That's okay. No worries. It's life.
Yeah, okay.
So sorry, so, your submissions of additional submissions yesterday included additional issues, included additional documentary or exhibit, evidence, and additional witnesses. You mentioned one expert witness.
Yes,
Those are all due,
yes,
and those are not allowed. You missed the opportunity to provide all those with your original notice of appeal.
yes,
So you making statements that that the appeal board is denying you these witnesses. Well, those witnesses that are being denied are not forming part of your initial notice of appeal with your list of witnesses.
okay, thank you. So again, I would just like to say for the record, I did request from you several times on what the clarifications on the procedures are. I asked you on the 3rd on my record. I spoke to you, Glenda, on the phone, and I was asking you when you phoned me Sunday, on I think it was December 3rd, and I asked you what I actually have it recorded at home. What was the process to this whole appeal? You didn't give me anything, and then on December the 16th, you guys gave us a 1-day notice for a procedural meeting. That procedural meeting, you guys could have told us that these were the things, but even before that, what was the appeal period for the record? Where does it say in the bylaw how many days is the appeal after the election? Can you please point that out to me in the section? For the record. Where does it say?
So if you take a close look at the elected regulations, and it corresponds with the definitions of appeal notice, reply notice, and submission of your appeal, and the
Yes.
election date. So when you
Yes.
correlate all that, then you come up with the due dates for whatever applicable submission that's to be made in respect to somebody's appeal.
Yeah.
So you just sort of have
Yeah.
to go through it and count the days.
Yes.
So you look at the election regulation as a whole and sort of calculate those numbers.
Okay.
And once you do that, then you're able to figure out, because I did that on my own too. I
Yes.
didn't go to the board or
Yeah.
even council or anything.
But
I
this-
sort of figured
okay.
that on my own. It was after our phone call
Yeah.
that we did this. So I didn't know at the time when
Yeah.
we spoke. Also, the December 16th meeting was not a procedural meeting per se in the way that you define it.
Yeah.
It was simply for the board to clarify some questions that they had
Yes.
on a number of your paragraphs or your
Okay.
grounds of appeal on your notice of appeal.
Yes. Okay. All right. But for the record, I did request in my things. I asked you on the appeal record. I asked several times on email. I asked you guys, when is the appeal over? And when you phoned me on Sunday, you said that the appeal was going to be over you told me on December 9th. And I said, how many days is our appeal? You didn't give me an answer. And I asked you, when can I hand in my evidence on the phone? And you said, you'll have to get back to the board. You didn't give me, and I asked you for direction and clarification. And this was before, so what day were you saying the appeal date was over?
It was December 11th.
Yeah, and you told me on the phone that it was December 9th, and I was asking several times up until December 9th, when you called me December 3rd, on the email and on the record, I asked questions. When can I hand in, provide evidence? When can I have some clarification? It's in my appeal record. Not one of you responded on that email. That was the only communication I was given, was the one email. And not once did you guys answer my question, because I was still within the appeal period to give whatever evidence needed to be in there and gather it. You guys could have given me a limit, but you didn't give me any notice or communication or clarity of the entire process. And when we went to the meeting on December 16th that you asked us the night before to come through the procedure meeting on the 16th, there you could have told us what was going on. You could have told us clarification. Well, this is when the appeal date was cut off. This is how many days the appeal period was. That's what should have been covered in the procedural meeting that you had. It wasn't a procedural hearing. But now you're making decisions based on that procedural meeting, and you said for the record, this wasn't an appeal hearing. It was a procedural meeting. You cannot make decisions to cut me off to say that I can't give evidence or any submissions when I've been asking for questions and you never answered them. You cannot make decisions at a meeting. You can only make them at a hearing when you're asked and saying, at this hearing, we're not going to give evidence or provide. You have to make that decision at a hearing. You cannot unilaterally make a decision that affects the bylaws and our process for the election to appeal unless it's a procedural hearing. That was just a meeting. You cannot unilaterally make any of those decisions, especially about anything in the bylaw. And when we were asking, we gave you guys lots of notice, lots of communication, asking you those questions, but none of you responded. Thank you. Okay, so I guess that's it for the record. That's what I would just like to state, that your I guess your answer or your end result was to say we can't give any evidence, but yet you could have given us notice. You didn't, that was a procedural meeting, you said, not a hearing. You can't make decisions that we can't give after the fact evidence provided. And that's a breach in the bylaw in section 25.8. Thank you. Okay, so I'll just move on to Lenny. Go ahead, Lenny.
Okay. I would like to call a witness, Teresa Healy, to the floor. Right there. Yeah. Okay.
And sir, would you mind guiding the board as to which grounds or paragraph in your notice of appeal that your witness is providing supporting evidence of? Please, thank you.
Yeah, got my book. It's right here.
Hang on.
Where's my papers?
I got these ones here.
No, it's these ones. Sorry about that. I don't have not a secretary. Okay.
The whole thing? Okay, based on the grounds here, unfair election process, number 8, the election process, including the notice of election and voting procedures, was fundamentally unfair. The designated advance polling date and electronic online voting periods, November 20th, 2024, and November 25th, 26th to the 26th, 2024, respectively, did not allow for adequate opportunity for eligible voters to campaign or cast their votes.
And there's another one. Oh, sorry about that. We can't overlap another one. This is the one. Trying to find the main point. Which is here. Yeah, we're going through this one. Okay, you're going to address this one anyway. Okay. Okay, these two, right there, 16 and 17.
Also like to address 16 and 17 on the grounds of lack of procedural fairness. Number 16, the entire election process exhibited a lack of procedural fairness essential for legitimate electoral proceedings. Candidates were not informed of their rights or the procedures relevant to the election, undermining the fundamental principles of democracy. And I'll go ahead and I'll start with the witness. For the record, do you want to state your name?
Yes, hello, my name is Michael. Hello?
Yeah, it's on. Yeah.
Maybe I'm talking a little too loud here. But yes, my name is Teresa Healy, and I am a witness to the election that's been compromised. And so I'm here. I went to. Oh, go ahead. Sorry.
Okay, that's okay. I have a few questions here to ask you in regards to calling you up as a witness. Number one, are you a member of the Blood Tribe and participate in the Blood Tribe 2024 election? Did you vote in the election online?
No, I didn't. I went directly to Lethbridge to vote. At the
Mail or in person? You just stated you voted in person, right?
Yes, I went
Okay.
to vote
Okay.
in person.
If you voted in person, did you receive an email that your in-person vote was successful?
No.
Okay, so you never received any. Okay,
No,
good enough.
no
Okay,
email.
moving on to question 2. Did you ever have concerns about who was managing the Blood Tribe 2024 election?
Yes. Basically, it was Lance Tailfeathers. He is in compromise with the election due to his conflict of interest. And not only that, I saw on Facebook that Sheldon had mentioned Binigoy driving people to the election and I believe there was money involved.
Okay. Moving on to the question number 3. If you participated in the election, what did you participate with?
I was witness to Leonard Eagle Tailfeathers. I was one of the scrutineers.
Okay. Is there any more in the aspect of this election? Did you partake in anything else? Did you serve anybody or along those lines?
No. Oh yes, of course. I was the person that gave the Nadine Tailfeathers the election. We were one of the elders' declaration. I gave it to her.
Okay. Okay. All right. Thank you. Are you aware of Lance working at KRI?
No, not later down the road. I learned that he was on that.
Okay. Are you aware that that Lance works at Kainai Resource Incorporated?
Now I am. Yes, I have been looking at some information on Facebook, and those came up.
Okay. Do you believe that's a conflict?
Of course it is.
Okay. Okay. Going on to question the next question, number 4. At any time during the nomination, were you a nominator? Who did you nominate? And if so, were you asked to be a scrutineer for anyone during the nomination period, which basically you just stated that you were a nominator?
I am a nominator for Leonard Eagle Tail Feathers.
Yeah.
I nominated him.
Okay, and in general, the scrutineer as well?
I was asked to be one of the scrutineers.
Okay. Okay. Moving on to number 5. At any time prior or at the nomination period of the election process, were you ever provided the names of the BT appeal board?
No. No, I didn't even know there was an appeal board.
Okay. All right. Are you aware that Rhonda Crow is related to Nadine Tailfeathers through marriage?
Not that I'm aware of, but I believe that's what's initiated in our comments, that there's some relation there.
Okay. Okay, thank you for your questions, for answering the questions. That's all I have for Teresa at the moment. My other witnesses didn't show, and so, you know, unfortunately, I did want to call them to the floor, but they're not here. So. Okay. Under the grounds of witnesses for examination, we call upon the following witnesses and candidates to be questioned as part of the appeal process. Elder Roland Cotton, he's not here. Elder Teresa Healy, Peter Chiefcalf, Elder Anita Eaglebear, Glenda Spotted Eagle, Bonnie Healy, Beamer, Traveler Plaited Hair, Roy Fox, Lance Tailfeathers, Ross Gary Scout, One Feather Heather Scout, representatives from the One Feather Online Voting Corporation and its directors, Lori Scout, Leonard Eagle Tailfeathers, DUANE Eagle Child.
Are you going to call Travis? Traveler.
Yeah, Travis Plaited Hair. Can you see if he's out there? Yeah, witnesses.
I guess for the record, we just like to say that these were the lists, and you guys didn't tell us that we had to contact them, that nobody gave us any direction, that you said this was our list that we could have relied on in my appeal record, but you guys never gave us any direction that we had to call them, because you guys were deciding how we were going to run this procedure for the record. There was no clarity that we had to call them, but they were on our record.
Are we okay with Teresa leaving? Yeah, okay, yeah. Okay, thank you. Travis Saint here.
For the record.
For the record.
So the board needs to compel him.
The board.
It's required to compel him.
The board is required to compel. It's a breach on section 25.
For the record.
For the record. Okay, we already called him Peter, right?
All right, so we'll go with DUANE.
Good morning. DUANE Eagle Child. For the record, I and we object to you make any decision removing our evidence and appeal grounds in your decision in your January 2nd letter. Because we never had hearing to this date, we had only had a meeting, not a hearing, on December 16th. With 1 day notice, we were denied making any submissions regarding our appeal and grounds. And because this was just a meeting, as admitted by the panel, no decision regarding our appeal is valid. And the panel lacks jurisdiction to make any decision without a proper hearing, and that is our position for the record again. Moving on, I wish to proceed with our witness testimonies. I respectfully request that my opportunity to provide any submissions. So what kind of appeal is this if we can't provide evidence? Thank you for the record.
So we have no more. I'm just gonna continue just reading off some of my submissions because we can't call any of the witnesses that were on the list and record. And it never said, you guys never gave us direction that we were supposed to call them. Everything, you guys had everything in your court. The ball was all in your court. We had no direction that we were supposed to contact them. We had them, and you guys had contact, or it means, excuse me, the appeal board had the contact and emails to all of the people that work for the BTA, the ones listed on there, which is on page 7 of my motion record, listing all the way from let's see, Bonnie Healy, Beamer, Travel Plotted Hair, Roy Fox, Lance Tailfeathers, let's see, representatives from One Feather and the directors, etc. For the record, you were the ones making that decision. You didn't give us any directions that we had, and we didn't have emails or contact information. We were only told to submit them back to the email, the Blood Tribe Elections Appeal Board. You didn't give us any direction that we had to call them and notify them, but you, the board, had contact with those applicants that I just mentioned, for the record. Yeah, and you should have compelled them because you knew they were part of the process, and that's a breach. Yeah, and you had the authority, you had to compel them, and that was to provide evidence to ensure that the process went through thoroughly. So how much time do we have left?
You have 13 minutes.
Okay. Well, since I have 13 minutes left, I'm just gonna finish reading off this. So, the actions of the appeal board and the CEO, Lance Tailfeathers, reflect the disregard for fairness and transparency. I need the mic. Such manipulations are not just procedural errors. They constitute significant violations of public interest that undermine the trust necessary for effective governance. The involvement of legal counsel with the appeal board raises serious concerns about conflicts of interest. While procedural guidance is appropriate, it is unacceptable for legal counsel to influence substantive issues of the appeal. This constitutes a clear conflict of interest that undermines our procedural rights and compromises the integrity of the appeal process. In conclusion, I implore the panel to recognize the gravity of the procedural violations we have outlined. The implications extend far beyond our individual appeals. They affect the very fabric of our governance and within our community. Upholding principles of fairness, transparency, and justice is essential for restoring trust in our electoral process. I respectfully urge you to allow for a comprehensive examination of the evidence, facilitated the attendance of the witnesses, and ensure our questions are answered thoroughly. Thank you for your attention to this matter. I look forward to your thoughtful consideration and fair resolution. So for the record, those questions that you asked us to submit yesterday in response, we don't even have any answers back. So we're just, at this point, it's not fair for us to answer any of your questions because we don't even have any of the answers that you told us to submit. Thank you for the record. So I guess this appeal is more than just about individual concerns. It is about the principles that underpin our community's electoral processes. The procedural breaches we have encountered cannot be dismissed lightly. They pose a threat to the integrity of our governance and the trust of our community. We urge you to act decisively to uphold the values of justice and fairness that we all cherish. Let us correct these issues and restore faith in our electoral system. For the record, we cannot answer any questions. We have not been provided any clear directions since we were requested answers from the beginning on June 3rd when we filed for the appeal. And again, the appeal board has violated the procedure. For the record, because you guys had called in for a procedural meeting. It was not a procedural hearing. And you cannot make decisions based on a procedural meeting if it's only on a procedural hearing. Therefore, you guys have unilaterally made a decision without informing us, because at that procedural hearing, you could have gave us the direction, which is the repetitive times from the beginning when I filed my appeal, when can I submit my evidence, and what's going on in this appeal process. You never answered any of our questions. When I showed up to the meeting, you asked points about at the procedural meeting, you asked 4 points for my appeal record. That is not part of an appeal meeting. That is part of an appeal process. And you have just violated and breached the entire process of the appeal process. You have unilaterally broke the rules and made your own rules as we went along. For the record. Could we take a break?
There is about 7-8 minutes left.
Yeah.
And if you don't have to fill your entire an hour and a half, if you're done, if you're concluded, you can conclude.
You have any questions to ask the board? Oh yes. We probably do have some questions for the board. How long has this appeal board, and this is for all of you because you're part of this process too. Rhonda, how long have you been on the appeal board?
I believe it was, you were appointed at a meeting of Chief of Council. The exact date, I believe it's the 26th.
The 26th of when?
Of 2024.
Of 2000. So you haven't been on the appeal board at all. Have you been on this prior, or this is the first time you sat on the appeal? Okay, so October of 2024. Okay, and
We were all appointed the same day.
okay, and I guess Rhonda, just another question. Is Nadine Tailfeathers any relation to you?
She's my sister in law.
She's your sister. And what is Nadine's position at PK?
Excuse me,
Yeah.
appellants, these questions are not in relation to your notice of appeal.
But this is part of providing
Yeah, but
evidence
I'm
for
gonna
procedural
have to-
fairness. So you object?
We've got to
So you
object,
object
yes.
for me asking questions? Okay, well, I would just like to know, this is part of procedural fairness, to get evidence. So Geraldine, when did you get appointed?
No, I've said this is.
Oh,
We're not allowing it.
Oh,
yes.
you're objecting us.
You are only allowed to provide some oral submissions in respect to your notice of appeal. Any other questions that are beyond the scope of the authority of the board, the bylaw regulations and what they have authority to, is not part of this appeal. So anything that happened before your submission of your notice of appeal is outside.
Okay, well, just for the record, that my questioning the board, any sort of substantive questions, it is relevant to this hearing to determine if the bylaws have been breached or any part of the process has been breached. Conflicts of interest, any conflicts of interest that are made relevant, you're not allowing me for the record to even basically address those. And I would just like to say that's another breach on the appeal board's process of Section 25, not providing evidence, and also the section where it talks about corrupt practices, and that's the appeal board's job to determine. So conflict of interest is corrupt practices, and so thank you for the record.
We have a question from one of our panel members.
At this point, I object until it's your turn, and we'll take a break. At this point, I'm going to have to object because we're still within our 7 minutes. So you guys asking any question to us, it's not your time. So I object. So we can wait till it's your turn. I would like to take a break now.
Break granted?
So you've concluded?
We've concluded until the end when we do our final comments. Right? We're allowed to have a final comment?
We're just taking a break, we're not
On the
concluding.
agenda, you have final comments, but you do have a right to cross-examine the two witnesses.
The two witnesses.
Yes.
Okay. All right, go ahead.
Honorable members, this appeal is more about this individual concern. It's about principles that underpin our community's electoral processes. The procedure breaches we have encountered cannot be dismissed lightly. They could pose a threat to integrity of governance and the trust of all of our community. I and we urge you to act decisively to uphold the values of justice and fairness that we all cherish. Let's correct these issues and restore faith in our victorious system. Thank you very much for the record.
Okay, thank you. So we can have our break?
Yes.
Okay, thank you.
Thank you.
We're not
Yeah.
concluding,
So,
we're just having a
We're
break.
having a
That's
break.
it. Yeah, just for the record, we're not concluding, we're just
Having a break.
having a break, so.
What was this bill?